Welcome to the Hunt and Hunt webinar on insolvent trading. Thanks for joining us today. I can see some attendees who are coming in. It'll just take 1 minute or so for everyone to be admitted into the live session. So if you just bear with us for a moment, we'll just allow more people to enter the room. You should be seeing on your screen a presentation with a slideshow that says top tips when negotiating with the ATO, and you should have the ability to send us through a chat or a Q&A. If you've got any issues and aren't seeing it, please send me a note and I'll see if we can fix this technical difficulty. But I can see many people entering, so welcome today. So we'll get started now. So welcome everyone, welcome to the Hunt and Hunt webinar on insolvent trading. Thank you for joining us today. This is a live webinar that is being recorded and you are welcome to ask any questions at any time. We will do our best to answer them throughout the session, but if there's a specific question that's asked, we'll take it offline and get in touch with you a little bit later to make sure that we answer any questions you have. This session should go for about 30 minutes and we're covering some really interesting and practical information that hopefully you can take away today. The objective today is to talk about insolvent trading and obviously in particular the director's liabilities, and to discuss the temporary relief that ends on the 31st of December. We'll also be touching upon the new small business insolvency reforms that have just recently been announced. And then we're going to be focusing also on the practical tips from Charles Babin, who's got many years experience working with the ATO. So hopefully there'll be some really key takeaway points that you can take away today to incorporate into your practice. So our panelists today are a very experienced team here at Hunt and Hunt Lawyers. We've got Matt Gauchi, who's one of the partners in the insolvency team. Matt works extensively in debt recovery and as well as litigation and disputes resolution, and obviously insolvency as well. We've got Lauren Boyd, who is also part of the insolvency team and is a senior associate in our Sydney office. And last but not least, we've got Charles Babin, who's also a partner here. Charles has over 30 years experience in debt recovery, 20 years at Hunt and Hunt alone, and also has over 15 years, as I mentioned earlier, working with the ATO. So he's our ATA guru here at Hunt and Hunt, and so he'll be giving some really valuable information. What we're going to be covering today, here's a list of the key points. Matt's going to be looking at the temporary measures that are expiring on the 31st of December, and also looking at generally the safe harbour provisions that are currently in place. Lauren's going to be touching upon, as I said, the small business insolvency reform, which were announced in September this year, and the legislation just recently been introduced. So it's really new information that is coming out, so that we don't really know the practical effect just yet, but we're wanting to explore it and making sure everybody has the knowledge they need if they want to access those reforms. Then Charles is going to be talking about some of his experience dealing with the ATO and providing some 5 key practical tips that you can explore in your own practice. So just get starting, what the climate's looking like at the moment, and a lot of the attendees today work in the insolvency industry, so they'll be aware of these kind of figures. But there's been a significant decline in companies being wound up in the past couple of months. Now, it seems a little bit out of line with what the current climate is with COVID and businesses saying that they've been impacted, but it's obviously coming about because of the government assistance that's being handed out at the moment, so JobKeeper, and obviously the restrictions also on the statutory demands and recovering debts. Now, the concern with this is that it's going to create an artificial sense of security for businesses, and directors aren't going to be accessing the temporary relief that's currently available to them. So the information we're getting and some of the feedback is that a lot of directors don't know or understand their obligations and the risks that's associated with insolvent trading. So the purpose of today is really to explain those risks, to give people a heads up that if they want to access these measures, then they can. So Matt's going to be delving into those risks and what can be done about it. So I'll be handing over to Matt now.
Thanks, Sarah. Since the temporary insolvency protections commenced in late March of this year, significantly fewer companies have been going into administration and into liquidation. This suggests that many directors have been deferring decisions about their insolvent businesses because of the government protections and other government support measures. Now, these government support measures in relation to insolvent trading liability are due to end on the 31st of December of this year. Now, there's been an extension in certain circumstances. Lauren will talk about those measures in the next section, but in any event, now is not the time to sit and wait. Failure to proactively tackle financial difficulties may result in personal liability for directors. I'll briefly talk about this liability for insolvent trading and some of the ways in which directors can protect themselves. Firstly, a company is insolvent if they can no longer pay their debts as and when they fall due. As you can see on the screen there, Section 588G of the Corporations Act provides that a director has a duty to prevent a company engaging in insolvent trading. The purpose of the section is to protect a company's unsecured creditors, in particular their trade creditors. The basic principle is a director that allows a company to incur debts while that company is insolvent may be personally liable for those debts. As you can see on the screen, the insolvent trading liability applies to a person who was a director of a company at the time when that company incurred a debt, and the company is insolvent at that time, or may become insolvent by incurring that debt. And at the time, there are reasonable grounds for suspecting that the company is or would become insolvent. And there are penalties for insolvent trading, and they can be civil penalties up to approximately $200,000. There can be personal liability for directors to compensate the company or its creditors for the amount of the debt that's been incurred. And there's possible criminal prosecution by the regulator, and that's ASIC. The Corporations Act provides a protection for directors from liability for insolvent trading, and that's called the safe harbor provision. And on the screen, there's Section 588GA of the Corporations Act, and that provides directors with protection from personal civil liability for insolvent trading if those directors suspect or should reasonably suspect that the company is insolvent. They consequently develop one or more courses of action that are reasonably likely to lead to a better outcome for directors than, or sorry, for the company, than immediately appointing an administrator or a liquidator. And in taking those courses of action, they cause the company to incur debts whilst it's insolvent. By way of an example, this company here runs a business where payment for its services are received at the completion of the project. And that's represented on the timeline there at the conclusion on the right-hand side. Along the way, the company incurs expenses, and they're represented by the various stars along the timeline. It's difficult for this company to delay or rearrange these expenses as they're fixed and relate to existing contracts that the company has with their suppliers. Continuing with this current model would mean that the company is likely to run out of cash very quickly. In this situation, the directors obtained advice and they developed a safe harbor plan, and that included 3 courses of action. The first being seeking to raise further capital. The second was to explore a merger. And the third, they attempted to negotiate or renegotiate the payment terms with the clients. The company continued to incur debts and paid their expenses whilst they pursued these courses of action. But unfortunately, the company ultimately went into liquidation. The directors here were not held personally liable for the debts of the company that company incurred whilst it was pursuing the courses of action. This case study, I should say, demonstrates that the time to act, if you're a director, is when you first start to suspect that the company may become insolvent. If the company is put into safe harbor sometime after directors suspect the company is or may become insolvent, then directors are potentially exposing themselves to some liability for insolvent trading. Now, there are certain conditions that need to be complied with in order to obtain the protection that the safe harbor provision provides, and we recommend each director seek advice relevant to the circumstances of the company. In addition to the general safe harbor protection, there is a temporary addition currently in force that was introduced as a result of the COVID-19 pandemic. As you can see on the slide, Section 588G AAA provides a temporary provision The duty to prevent a company from insolvent trading does not apply in relation to a director and a debt incurred by a company if that debt is incurred in the ordinary course of the company's business between the period of 25 March and 31 December of this year, and before any appointment during that period of an administrator or a liquidator. Essentially, this temporary safe harbour provision protects directors from insolvent trading liability in respect of debts incurred between 25 March and 31 December of this year. Unlike the original safe harbour, directors here are not required to develop a course of action. However, there is a requirement that an administrator or a liquidator be appointed to the company before 31 December of this year in order to gain that protection. And 31 December is fast approaching. With that in mind, directors of companies which are suffering financial distress, whether that be due to the COVID-19 pandemic or for some other reason, ought to review the financial position of the company now and make a decision whether their business is capable of surviving beyond 31 December. A director may decide that the company ought to be placed into voluntary administration now in order to take advantage of this temporary safe harbour protection. If a director is finding it difficult to predict the likelihood of their business surviving post 31 December, and they're not willing to commit to making a formal appointment of an administrator now, of course, the general safe harbour provision can still be relied upon, and advice should be sought shortly to start to develop a formal plan of action to gain that protection. There are also reforms to the insolvency laws that are due to commence from 1 January of next year, and they create a new debt restructuring process for eligible small businesses. Lauren is going to talk about this in the next section, but I raise that now as insolvency practitioners will shortly commence going through the process to obtain registration to facilitate these reforms. And during that period, there'll be a 3-month transition period from the 1st of January of next year through to the 31st of March. During that period, the temporary safe harbour protection can still be relied upon by directors of companies if that company declares their intention to access this new restructuring process. That declaration can be made through the ASIC Published Notices website. Directors may still need to seek advice to ascertain whether their company is eligible. So if you're a director or you have a director as a client, here are some tips on what directors should be doing now. Firstly, they should inform themselves about the company's financial position and its affairs. They should assess the company's solvency and investigate any financial difficulties immediately. They should obtain professional advice to help address any financial difficulties that they're currently facing, and also advice concerning the capability of the business to survive post 31 December of this year. They should consider that advice, including whether or not to invoke either of the safe harbour protections. And I think most importantly, they should act in a timely manner in whatever way they choose to act. So if you're a director or you have directors as clients, now is the time for advice to be sought to protect themselves. Lauren will now go into the insolvency reforms and explore those measures that are coming into effect from next year.
Hi everyone, today I'll be touching on the proposed small business insolvency reforms, which have been described as the most significant development to the Australian insolvency framework in almost 30 years. I know some of our attendees today are insolvency practitioners themselves who will already be aware of the two things I'm about to mention, but for the benefit of the directors who will be attending, I should make it clear firstly that the legislation I'll be referring to hasn't actually passed yet and may change before it is proposed to come into effect on 1st of January 2021. Secondly, looking at the legislation, we need about 50 lunchtime webinars to cover all the ins and outs of the changes. So this is not intended to be a comprehensive review or summary of the proposed legislation. It's simply too much for that. Instead, I'll be mentioning a couple of points of interest and also the role that the ATO might play once the reforms come into effect. If you'd like to know more, please contact us and we can give you advice specific to your circumstances and refer you to an insolvency practitioner if appropriate. So the changes aim to allow Australian small businesses to quickly restructure and to survive the economic impact of COVID-19. On the slide, you'll see a graphic summarising how it is intended to work, but the legislation itself isn't quite as straightforward up and down. Where restructure is not possible, eligible businesses will also be able to wind up faster, enabling greater returns for creditors and employees. These changes form part of the government's JobMaker plan to ensure Australia emerges from the pandemic with a stronger, more resilient and more competitive economy. Employees and capital will shift from less profitable to more profitable businesses. So for a business to be eligible to restructure, all employee entitlements, including superannuation, must be paid. And all taxation lodgements, including VADs, under restructuring must be up to date, but do not necessarily need to be paid up to date. It's just the lodgements that need to occur. Interestingly, the substantial compliance wording we saw in the Safe Harbour reforms has reared its head again. This is obviously a subjective measure, and it will be interesting to see the different interpretations of that phrase. For a restructuring, a majority of unrelated creditors in value only, as opposed to number and value, must accept the proposal for its accepting. Now, the alternative or the subsequent process is the simplified liquidation process. For businesses eligible for the simplified liquidation process, all taxation lodgements must be up to date. The government has announced it will also consider permanently raising the minimum threshold at which creditors issue a statutory demand on the company, but have not said when or how they propose to do this. Currently, the minimum threshold is $20,000. That's a temporary reform in place, up from $2,000 pre-COVID. It's important to note that for many small businesses, the ATO is often by far and away the majority unrelated creditor, and in many cases would be the sole decider of whether or not a proposal is accepted on behalf of all creditors under restructuring. As this legislation hasn't passed, the ATO haven't published a practice statement or any guidelines as to what approach they will take, and whether they'll be seeking advice from their lawyers in review and dispute resolution, or from panel firms, but we expect decisions will be made on a case-by-case basis. Usually the ATO would not be willing to compromise the primary tax step for a number of reasons, policy being one of them. If they allow some businesses to not pay their tax, other businesses will have little incentive to pay their tax either. It will be interesting to see the extent to which this might change, as the ATO seems to be shifting its focus from compliance and debt recovery and takes on more of a support role for businesses post-COVID. The ATO do still have advantages over other creditors. In addition to lodgements needing to be up to date, in some circumstances, directors will remain personally liable for debts incurred by companies, even if they are otherwise compromised as part of a restructuring plan or if the company is liquidated. Directors, if this is a concern to you, it's important you seek advice early, and if your company is in financial distress, seeing an insolvency practitioner sooner rather than later is definitely a good idea. That way it may be possible to informally restructure without having to resort to these formal measures. A final point I'll make before handing over to Charles is whether the reforms are likely to be widely used in circumstances where the ATO is going to be the majority creditor for many businesses. We would think that in a company with a restructuring proposal that would be acceptable to the ATO might just be better off negotiating payment arrangement with them directly instead of resorting to this process. But also, in contrast, if a business hasn't been able to negotiate a payment arrangement, there might not be any point undertaking this new restructuring process. So insolvency practitioners will no doubt be keeping this front of mind when they are approached by directors looking to discuss their options. Charles, over to you.
Okay, I think I'm on. Okay, so as Lauren just alluded to, the ATO is likely to be, if not the largest creditor, certainly a creditor for most of any of these restructuring plans that are contemplated under the new legislation. It may be that if you've been unable to negotiate an arrangement with the ATO in relation to its debt, then they're not likely to be going to vote in favour of your restructuring plan later on. So hopefully these tips can help you and your clients in your negotiations with the ATO and achieve an outcome before you have to consider an insolvency administration. All of the points there need to be considered in light of one of the big distinguishing factors of the ATO compared to other creditors, and that is that the ATO is not a commercial creditor. I say that in the sense that too often when we were acting in matters with the ATO, and debtors would contact us and say something to the effect of, look, if you wind us up or if you bankrupt me or my client, you're not going to get anything. So what's the point? We'll offer you $5,000, $10,000, $20,000, whatever it might be, for you to stop the action. Now, a trade creditor might consider that a bird in the hand is better and therefore accept an offer of a compromised debt. The ATO won't. The ATO considers that if they accept less than 100% of the tax debt, then what they're doing is giving a benefit to debtors who don't comply with their tax obligations over those that do. And public policy considerations dictate that that can't be done. So bear that in mind when you're having negotiations with the ATO. The first point there is to get in early. And by get in early, we mean get in first. Don't leave your tax debt to be addressed until such time as the ATO contacts you. It's much better for you to get in contact with the ATO. Let them know if you're going to be late in a payment, whether it be a GST payment, a tax instalment, whatever it might be. Ring them up, go on the portal, whatever you might do, but get in contact with the ATO, explain your circumstances, be realistic, and ask for an extension. You might think that if it's only going to be a week, what's the point? If it's only going to be a month, nah, the ATO won't do anything in that month, so let's let it ride and then just pay late. It's much better to have got the formal extension from the ATO and then pay on time in accordance with that extension. You'll actually find the ATO is quite accommodating if you're not already on their radar as having defaulted in a payment. And be aware that once a matter goes legal, that is referred to the in-house ATO legal team or to external lawyers, then different considerations apply, different timelines apply to your circumstances. So if it gets to the stage of a bankruptcy or winding up, then it's not a question of collecting the debt anymore. It's a question of whether you're solvent or not. And that's much more difficult. So get in early, try and negotiate. The second point there is communication. That's tied in with the first point, obviously, but as far as the ATO is concerned, a debtor who communicates is one who is opting into the system. If the ATO can't get in touch with you, if you're late in your payments, or if you haven't communicated with them to try and do something about it, then the ATO takes the view that you're opting out of the system. And if you opt out of the system, the ATO will have no hesitation in taking you out of the system if you don't want to be a part of it, and they'll wind you up or they'll bankrupt you. So it's amazing how often we were contacted once the matter had been referred to us. So we're at the end of the line here in the collection process, and we'd be contacted by tax agents or debtors and say, oh, I really should have done something sooner, shouldn't I? And it goes without saying that's the case. I mean, in the case of an individual, for example, the ATO has tried to get in contact with them. The ATO's commenced proceedings. The ATO's got judgment. They've issued a bankruptcy notice. Non-compliance with a bankruptcy notice. It gets referred to external lawyers. Creditors' petitions filed. And then the taxpayer says, oh, I better do something about that. It's serious. It's going to be much, much harder for a negotiated arrangement to be entered into once it gets to that stage. The third point there is keeping your financial records up to date. As part of any negotiations with the ATO are more than likely to say they will ask you for your financials, often going back 1, 2 or 3 years. And part of the reason for that is that in assessing a payment arrangement proposal, the ATO will do its own business viability assessment. So if the arrangement's being sought, what you have to do is make sure that what you're offering is not only something that you can afford, but it's the most that you can afford. And you have to demonstrate that in your financials. Submit a cash flow projection with the intended payments in it to show the ATO that it's not only what you can afford and therefore able to comply, because the ATO doesn't want you to not comply either. And you certainly don't want to not comply, because debtors with a history of non-compliance are far less likely to get any sympathy from the ATO when negotiating a further payment arrangement. Also, if your financials are up to date and you've kept proper books and records, it demonstrates to the ATO to some degree that you have a proper business skills and administration skills, and it gives them somewhat more confidence that you'll be able to comply with a reasonable payment proposal demonstrated by your financials to be something that you are able to do. The next point there is be aware of your options. As I noted above, far too often people ask for things that the ATO just aren't going to be able to do. They're not going to compromise your debt by accepting 50 cents in the dollar. Right? So be aware of what options are available. If you're seeking a GIC, general interest charge remission, then be aware of the practice statement that the ATO has issued that they apply when they're considering your remission request. In effect, if you're demonstrating that circumstances beyond your control caused you to be late or not to pay your tax debts on time, then give evidence of what those circumstances are. Medical evidence is the one that comes to mind most readily. Give them medical certificates. And if the medical certificate says you were unable to work and therefore comply with your tax obligations for a period of time, don't ask for a remission outside that period of time, because you won't get it. And if you start asking for things you can't get, you may not get the things you can get. It'll be interesting to see whether and how the ATO treat the pandemic as a circumstances beyond the control of taxpayers when it comes to general interest charges that may have been accruing. So be aware of your options, and one option which you ought to be aware of, which the ATO is becoming more and more favourable with, was seeking a secured payment arrangement from the ATO. If, when you're doing your cash flow forecasts, you come to the view, and the ATO also comes to the view, that the payment arrangement which has been proposed is not reasonable because it will extend over too long a period of time, then what would ordinarily be unacceptable on an unsecured arrangement may become something that is acceptable on a secured payment arrangement. The ATO only accept real property as security, and taxpayers would need to seek advice as to the consequences of turning your unsecured liability into a secured liability. But in some circumstances, it's an option that allows you to continue on with an arrangement with the ATO when otherwise it might not be available. The other point which I've got there is to not prioritise other creditors. Now, I appreciate that sometimes that is extremely difficult. You have to pay rent if you don't want the doors shut. Trade creditors have to be paid in order for you to continue with your business. But the ATO does not like being put at the end of the line when it comes to payment. So if you're seeking a payment arrangement and you submit your financials and cash flows and whatever it is the ATO asks for to the ATO, and they see that you've got, for example, large car loans for exotic cars that you may have, or you're paying your credit card down because you've put all sorts of lavish expenses on your credit card, and you've been making those payments, but you haven't been paying the ATO or trying to enter a negotiation with the ATO and pay under an arrangement, then the ATO rightly says, you're not treating us with the respect we need, and they'll be less likely to grant you a payment arrangement in those circumstances. So just bear it in mind that the ATO ought to be treated the same as your other necessary creditors to keep your business going. In effect, that's the 5 tips for you. The ATO will, in summary, accept a payment arrangement that is reasonable. Right? They don't come to you with a payment arrangement. They expect all their debts to be paid on time in full. But if you put a reasonable payment arrangement to the ATO, especially if you do so early, then there's a good chance that it will give it proper consideration and allow you to enter into that arrangement. I hope those tips help you in your negotiations with the ATO. Those 5 points are on our website with a brief commentary. If you need any further information or assistance, obviously, we're happy to help. Back to you, Sarah.
Thank you, Charles. Thanks for that really insightful information. And I know a lot of the attendees who are here would get a lot of value out of that insight. So appreciate you going through that in detail. And as Charles mentioned, there is an article on our website that you can check out. We're also here if you pick up the phone or send us an email and happily answer any questions. Hunt & Hunt's a firm that's been around for 90 years and has a fantastic reputation as helping businesses from small to large and institutions and individuals. So we just recently, sorry, I didn't introduce myself at the start. I'm Sarah Capello. We merged with Hunt & Hunt at the start of October, and they share a lot of the same values that we have, and are fantastic with helping clients to succeed. Now, I have received some feedback in the chat that there was a few sound issues with Lauren, so we apologise for that. What we're going to do is we'll send through a copy of the transcript, because Lauren had a lot of really detail that will be relevant. So we'll send that through when we send through the recording as well as the presentation, so you can go through that later on. But if you've got any questions now, then please shoot them through. We have, a minute or so. We're right at the end of our 30 minutes, but we'd love to answer any questions. We've got one that's come through from Nick that we can answer. And the question is, there's lots of discussions about the effect of Section 5888GAAA and the 31 December date. Do you need to appoint a liquidator before or after this date? So Matt, if you would, or Charles or Lauren, if you wouldn't mind answering that question for Nick.
Nick, as we understand it, as I understand it anyway, under the current legislation, you need to appoint before the 31st of December to get the benefit of the temporary insolvent trading provisions. However, if that will be extended to the 31st of March, if you lodge notice of your intention to utilise the small business arrangement. So as it currently stands, my understanding of how it currently stands.
We've got another question that's come through. Sorry, hopefully, Nick, that answers your question. We've got a quick question from Andrew, who's asked, as the legislation currently stands, will the 21-day statutory demands for $2001 debts be able to be served on 2 January 2021?
Yes, is the short answer. And stand in line is my understanding of it. Certainly, we've been advising our creditors, as I'm sure others have, that once got inside the 6-month period, up to 31 December, there was no point in issuing a statutory demand because you could issue one on 2 January for the 21-day period, and the date for compliance would be sooner than if you issued one today, obviously, but any time in the last 5.5 months. So, as I understand it, and from talking to people, there is a lot of a backlog of statutory demands, and I expect the ATO may be one of those who will be lining up with a long list of debtors who they're going to be issuing those demands.
So a good practical point to note there is be prepared if there's going to be a huge number of clients coming forward wanting instructions to prepare statutory demands to get them issued on 2nd of January. Be prepared in advance. Understand what the closure periods are for advisors or companies that are open, and make sure that you factor in the holiday period and any of the public holidays. So prepare now in order to issue them later on. We've got one more question that we'll answer, and then we'll take it offline after that. And if there's any other questions, you can email me after the webinar. But the question we've got from Daniel is, will liquidators be able to pursue unfair preferences for the COVID-19 period up to 31 December 2020?
The answer to that is yes as well. There was some talk that the ATO was trying to have a position whereby it couldn't be chased for preference payments, but as I understand it, nothing came of that, and there's been no temporary changes to the unfair preference or any other avoidable transaction position.
Yeah, so that's a really great point to make sure you're aware of those preferential payments, the risk of associated with that. Now, going to the last slide, looking ahead to 2021, there's lots of exciting things happening here at Hunt & Hunt in 2021. We've got some great webinars that are coming up. There's a range of topics, but just a quick note here, we'll be talking more about debt. So this first webinar is one of a three-part webinar series where we'll be focusing on insolvency and some debt post-COVID, because we believe that there's going to be a lot of activity next year. So Charles, Matt and Lauren, as you can tell from today, are a very experienced team and are wanting to help as many of our clients through this process as they can. And we're going to be sharing as much information for our referral networks as well. But if there's any specific topics you'd like us to address, then please get in touch with us. Otherwise, again, it'll be focusing on those insolvency regimes, in particular the small business reforms, which are pretty huge, as well as the post-temporary relief era and the post-government stimulus era. We'll also be focusing on employment law. So particularly for myself, I run the employment team here at Hunt & Hunt. Post-JobKeeper, we're expecting there's going to be potentially some issues that flow from the measures that were temporarily put in place, particularly if some of the directives were not issued properly. So what we always telling clients is make sure you get the right advice and execute it properly, because with employment law, you expose yourself again to quite a few risks. The last one, which is a really exciting topic, is data and privacy. We've got some fantastic lawyers here who are, essentially experts in their field, so they'll be presenting on some of the new upcoming legislation the areas to focus on with businesses. So there's a list there of the kind of work we do here at Hunt & Hunt. As I mentioned earlier, we've been around for 90 years. We're the only law firm in Australia who's part of the Interlaw global network of lawyers. So we have fantastic connections to other firms across the globe, and we've got offices nationwide. So we'd love to hear from you. We hope that everybody has a safe and enjoyable Christmas, particularly after the year that we've had, and we look forward to seeing you on the new year. So we'll be signing off now, and we'll be sharing all of these, the presentation and the recording in the next week or so. Thanks very much, everyone, and we hope to see you again next year.
Thanks, everyone.